Morning, everyone, and thank you for joining our panel discussion on the Code of Good Practice on the prevention and elimination of harassment in the workplace. We thank everyone for making the time this morning to join us for a very important discussion with a code that will have great impact in the workplace and that triggers various obligations on employers to review policies, but also to possibly educate and update their employees and on the additional obligations. My name's Annie Besaidnout, and I'll be joined by a panel of 3 of my colleagues who are all directors in the Employment Law Department. I will kick off by giving you an overview of the code and its effective date, and then we'll start discussing the intricacies. We encourage all of you to raise questions in the chat box as we go. We'll try and get to them during the course of the presentation, alternatively at the end, with the time permitted for us to do so. Let me briefly take you through some of the basic principles of the code, just so that you have a good overview in listening to my colleagues. The first item that has been changed and the scope of which have been increased is the application of the code. So the code applies to employers, employees, applicants for employment, and volunteers. But I think what is very important is that the definition for perpetrators, or the description rather, of perpetrators and victims of harassment can now include various parties, which includes owners, clients, contractors, employees. If anyone visiting your premises or that may be at your premises can now be the perpetrator or the victim of sexual harassment. Now, my colleagues will talk to you about what does that mean, because in our view, it means at the very least that should you have any induction policies or any other documents or courses that you take anyone through that enters your premises or visits your premises, there may now be a need to also discuss the provisions of these policies. Regarding the scheme of the code, which we'll also be discussing today, the scheme of the code regulates substantive and procedural aspects. It tells you how these matters should be addressed. It places various obligations on you regarding confidentiality. It also introduces new concepts, which is a positive development. It creates the protection for racial, ethnic, and social origin harassment. It also creates new protections for the LGBTQIA+ community, which we haven't seen provided for specifically previously. It places proactive steps on employers that they need to take, which we'll take you through today so that you also know what to expect and what to review. My colleague Imran will talk to you about the zero tolerance stance, which the code now requires you to adopt, and how your policy should be updated to align it with the code. So without further ado, I'm going to hand over to Heda, and I'm going to ask her the first question, which I think is most relevant and which has been in the forefront of everyone's minds in considering this code, and that is sexual harassment. Where does the code leave us in relation to sexual harassment? Has harassment generally now been defined? And where do employers now stand in relation to their obligations in relation to that?
Thank you, Anne-Lee. Good morning, everyone. Thank you for joining us. Well, there haven't been any significant changes to the code. However, it is noteworthy that the definition of sexual harassment has been shortened to wording as unwelcome conduct of a sexual nature that violates the rights of an employee. It takes further into account whether the harassment is on the prohibited grounds of sex and/or gender and/or sexual orientation, whether the sexual conduct was unwelcome, the nature and extent of the sexual conduct, and the impact of the sexual conduct on the employee. The test for establishing whether there has been sexual harassment takes into account whether the harassment is on the prohibited grounds of sex and/or gender and/or sexual orientation. So as you can see, Annelie, it's quite broad, and the following must therefore be considered in this regard by any employer who's dealing with an allegation of sexual harassment: whether the sexual conduct was unwanted or unacceptable, so that there's no change in relation to that, the nature and extent of the sexual conduct, and the impact of the sexual conduct on the employee. Importantly, what's now been included is violence and harassment in the workplace is wider than sexual harassment, and the code requires employers to implement measures that will combat all forms of violence and harassment in the workplace. So it goes to your earlier point, Annelie.
There's been a debate in most judgments, and I think the difficulty we sit with is in any sexual harassment investigation where there's an element of sexual conduct. The question is really, was this action unwanted, and what is unwanted has been considered by our courts, but has the code taken the matter any further for employers during their assessment and investigation to better determine whether they sit with a situation in which the conduct was in fact unwanted?
Well, in that case, in that assessment, only I would suggest or would propose that there hasn't been major changes, in the sense that you would still investigate, you would still take the complainant's grievance, you would still consider the grievance, and you from that you would take on further what is required of you as the employer in that scenario.
I think, Hera, what was very interesting to me from the code is that it goes much further than its predecessor, which was the 2005 code, in that it now introduces, I think it's in paragraph 4, if I'm not mistaken, the various concepts of harassment. Now, yes, from my reading, the ones that were quite interesting to me were the passive-aggressive harassment, the psychological harassment. We now have cyber harassment. Can you take us through some of that concepts, and where does that leave an employer?
So just for our listeners today, psychological harassment in terms of the code has been defined as in the workplace may be associated with emotional abuse and involves behavior that has serious negative psychological consequences for the complainant, which in terms of the code, you will see there's reference to verbal abuse, bullying, and mobbing. Passive-aggressive or covert harassment may also include negative gossip, negative joking at someone else's expense. This can also include conduct such as condescending eye rolling, facial expressions or gestures, or ridiculing the employee, or even deliberately causing them embarrassment. So you'll see that the code has gone far wider, and in that regard, obviously with the major numbers of people dealing with mental illnesses, it's obviously been part of the consideration in terms of the code, is that we take these instances or these issues into consideration when we're dealing with our employees. It's no longer simply accepted, well, I didn't mean it, or you misunderstood, because the perception is obviously taken from the employee's perception as to what you had said to me or how you had said it to me, and how I've then perceived that conduct from you. So it's extremely broad, as we've already debated only how broad this code is. So employers and managers, supervisors need to be extremely not wary is mindful of how they deal with their subordinates and how they engage with their subordinates, because bullying, as the most extreme example, will no longer be accepted in terms of this code, and our employers need to make sure that there is awareness training, that all employees are fully cognizant of the fact that their previous behavior is no longer accepted. And if I can extend it, one often hears from our clients, there's a bully amongst us, but he performs extremely well, he gets the team to manage extremely well, but those are issues that are going to have to urgently be assessed and dealt with, and that type of employee, whether he be a supervisor or a manager, is going to have to be given the awareness training that he or she or they become aware that their conduct is simply not acceptable anymore, and that it impacts negatively on an employee. And it's not simply a case of, well, shame, he or she or they was too soft, doesn't understand what I'm trying to get out of my employee, etc. So those are all of the things that our clients and employers specifically now need to consider when they roll out this training for their employees.
I think what's also very interesting is that the code specifically refers to professional isolation and sabotage. I think that it calls it sabotaging of career performance. Now, the question that triggered with me is really, well, our performance discussions always have to be robust. You have to give a certain level of feedback. But when does feedback, critical, robust feedback, when does that border on professional isolation or sabotage of career performance? And the only real solution I can think of at this point, and Hera, I'd like to hear your views as well, is that the guidance must probably be given to employees to the extent that you give feedback, keep it objective. Don't get into subjective elements that can't be substantiated with reference to objective evidence or with whatever the documents may show. Just keep it neutral if you can.
Absolutely, and what's key here is professional. You need to be respectful, you need to be professional, and as you say, you keep it to the objective points of my performance. You're not going into my type or subjective, where I don't appreciate you doing A, B, and C because this is not the way I do it. It's got to be an objective assessment of whether I'm performing or not. Absolutely. And again, it goes to my point, and I'm going to obviously emphasize this, or we're all going to emphasize this today, is that training is critical. Our processes exist for fair procedures in our labour law, and employers need to make sure that they are cognizant of that. Again, it goes to your point, Annelie, we must make sure that it's an objective assessment. What I would say is that it needs to be properly minuted. If possible, don't do it on your own, because it may be perceived as being an incorrect behaviour, or you had said something wrong that I had perceived as something incorrect. So if it is a large enough organisation, there's no reason why an HR representative perhaps can't form part of those discussions. So the key and the critical point, or the takeaway from this, is it's got to remain professional, it's got to remain objective, it's got to be respectful in terms of in order to ensure that you remain away from any allegation of professional isolation, or you have now sabotaged my career growth within the company.
I think on that note, let's go to the question of James. So he says, with regard to the scope of application, would the code extend to business forums on site harassing employees for subcontracted work, and should employers take proactive steps to prevent this from happening? I think the short answer is yes. The scope of the code is now wide, in that anyone entering your premises, their conduct can be scrutinized in terms of the code, and your employees should be protected against them. That's the brief response, James.
Absolutely.
Then Francois is asking, any changes, Hida, on burden of proof in cases of harassment where you deal with two mutually destructive versions?
No. So our test in terms of our law would remain applicable. You would still conduct the investigation. You would get an independent person then to chair that inquiry or that grievance, and that person would then have to determine on the basis and be guided by our case law in relation to two mutual destructive versions as to which version is more the credible version, and whether it's substantiated by witnesses, or whether there's something that I can prove that this is effectively what had happened to me. And that's why I then assess that evidence that is given to me as the chairperson, and then I will, from a credibility, I would make a finding as to which version, on a balance of probabilities, is more of the in inverted commas, the correct version.
And then it says, does the code consider bottom-up harassment, subordinate bullying a line manager? I think, if I recall correctly, it doesn't necessarily use that wording, but it would definitely be covered in the scope.
Well, absolutely. Given the broad nature of this code, I think it foresees scenarios that we can't even think of at this stage. It's that broad. Absolutely.
All right. So Bongani, I think we've touched on it briefly. There's some very positive developments in terms of this code. It has now taken us through the extensive scope and the difficulties we may face with that, but then the positive developments, if we now have protection for LGBTQIA+ community, and we also now have specific provisions relating to racial, ethnic, and social origin harassment. Would you just take us through those briefly as well, please?
Thank you, Annelie. Good morning to everybody joining us. Starting with the reference to LGBTQI, in fact, it's LGBTQIA+, that is referred to in the code. The code obviously draws from the ILO Convention 190, which is the code dealing with the elimination of violence and harassment in the world of work from 2019. And borrowing from that convention of the ILO, it has adopted an obligation to put in place a legislative framework or regulatory framework that is gender responsive, over and above just being just eliminating discrimination on the basis of gender. But there's a positive obligation in the code to create an environment or to adopt approaches and means of eliminating harassment on the basis of gender, and this specifically refers to the LGBTQIA+ community. And in that regard, section 4.7.3 mentions that any employer must ensure that there is an elimination of any phobia against the members of the LGBTQIA+ community. The other interesting thing only is that there is also a specific mention of gender-based violence, GBV, in the code, and there's a specific obligation to ensure the elimination of gender-based violence in the workplace, and not just harassment on the basis that somebody is male or female, but specifically targeting gender-based violence. So that is the first thing that I think is important to cover in relation to the LGBTQIA+ community and GBV. And in terms of the racial harassment part of things, it includes obviously ethnic and social origin, and it's specifically intended to be eliminated by the code. On racial harassment, there is a test that the code establishes, and that test is that anything said or done in the context of a workplace that is reasonably capable of conveying a racist meaning to a reasonable hearer, or a person who's listening to that being a reasonable person, which suggests that it's an objective test, but at the same time, it's quite a broad test in the sense that, you know, anything reasonably capable of conveying a racist meaning, said or done, is in my view quite a very broad test. And to go back to the question earlier that was asked about the onus and all of that, the test itself also is part and parcel of something to be considered in relation to how the onus would unfold. So the test remains on a balance of probabilities. It's never going to be beyond all reasonable doubt like in the criminal courts, but we know that it's an objective test in the sense that it is not just a subjective view of one person saying what was said to me reasonably or is reasonably capable of conveying something racist, and that is the end of the inquiry. But the inquiry is, would that have been perceived as something that conveys a racist meaning by a reasonable person rather than by the person specifically involved. So Heda's point, I think, is quite important in relation to, we still have to conduct investigations. We still have to go through grievance policies and procedures. We still have to listen to evidence on both sides of the table and decide whether or not, on a balance of probabilities, the test for racial harassment has been met as one of the examples of harassment in this context.
I think that ties in with Karen Smith's question. She asked, is the code open to abuse in any way? Do you think the wide scope of Ghani leaves you with possibilities of abuse? And if so, if you're an employer and you're faced with allegations that you don't necessarily believe are true, where does that leave you and what are you required to do?
So I think, like all things in life, there is a possibility and a potential for abuse, particularly taking into account the wide-ranging nature of what harassment is in this instance. Obviously, the code makes it very clear that every case is to be looked at on its own merits. So you will decide every case, the merits of each case on a case-by-case basis, on an ad hoc basis. But I think there's definitely room for some abuse in relation to certain persons who may make certain allegations of harassment against people just because of the wider scope now. I mean, it includes things like cyberbullying. One of the things that has been mentioned, some of the things that you mentioned, Anli, are professional bullying, the manner in which managers are able to give feedback to employees is going to come into question quite, I think, much more than it used to before, which leaves some room for abuse, but all is not lost because obviously the test that is set there is quite an objective test, and just because somebody has made an allegation subjectively does not mean that that is the end of the inquiry. The inquiry must be conducted objectively, and decision makers must decide on the balance of probabilities whether the allegations raised have been proven or not proven. And then as to the consequences for any finding that an abuse of the code or the intention of the code has been committed will have to be dealt with separately. We know that there could be disciplinary action for persons who make certain allegations which are unsubstantiatable depending on the seriousness of the allegations so being made. So room for abuse, yes, I would think that it existed even before in relation to the 2005 code. But I think that the wider scope of the code definitely means that we're going to see more and more of these cases arising. Whether with merit or not will be a different question.
Well, the items we're discussing this morning, they're obviously very sensitive in that whether or not you allege racial harassment, whether you allege sexual harassment, it's sensitive matters which have severe consequences should someone be found guilty or should it be found that someone had in fact lied. Does the code require any form of confidentiality on either party? And how should an employer go about treating these matters to ensure that it doesn't go wider than is intended and that people that aren't necessarily involved don't know about the matter, just I think because of the sensitivities?
That's an important question, Anli. There's a very big emphasis in Section 11 of the Code on confidentiality, and it is spelled out quite specifically. It goes as far as to say that the information exchanged during a disciplinary inquiry, for example, must be kept confidential. It goes as far as to identify the persons that must be involved in a disciplinary investigation, in a grievance investigation, and it says the persons that are the person against whom the allegations are made, the complainant, the members of management who are specifically responsible for either the grievance itself or handling of the grievance itself, or the people that are members of management that are responsible for the management of discipline in the workplace, particularly in relation to those kinds of allegations that have been raised, must be the only people involved in the disciplinary inquiry, and that the record of that disciplinary process must be kept confidential from persons who. So in other words, what we see here is a creation of a need to know basis kind of disclosure. So the disclosure of disciplinary and other records relating to harassment or the various forms of harassment would be limited to those persons on a need to know basis. So, you know, I would think that this is quite an important step that the regulatory framework takes to protecting the confidentiality of the information that is exchanged between parties during allegations of harassment, including racial, sexual, and other types of harassment that we have seen. And I think it's for a good reason as well, because obviously these things are always subject to some abuse. And at the same time, there is some stigma. If you imagine, for example, a member of the LGBTQIA+ having been subjected to some harassment or an overt act of phobia, you know, by members of management, and for them to be able to come forward, they would need the comfort that whatever they exchange there is to be kept as confidential as the circumstances require. So I think on the one hand, it's definitely going to increase the number of cases that we see coming before the CCM and other bargaining councils on this, and the Labour Court. But at the same time, I think that the level of confidentiality that the code requires in handling these matters is quite importantly what is required to ensure that those instances of harassment that we have occur in the workplace are no longer sort of suppressed and pushed under the rug. That people have the confidence, or employees and other members, of course, because the scope of application is wider than just employer-employee, that people are free to be able to bring their complaints forward without fearing that they would be shamed or stigmatized after the fact.
We've discussed that the code possibly extends beyond employer-employee relationship, and Samantha Anderson has asked the question, if the harassment had to occur on site but between non-employees, contractor employees, what are the holder client's obligations and how should such incident be handled?
So it's quite important that the code casts the scope of its application quite wide, and quite specifically independent contractors, external parties, clients, and the like are all included in the application of the code. So an employer would take upon an obligation to deal with all of these harassment allegations and issues that arise in the workplace, and it goes as far as even beyond the workplace. It's not just instances that occur in the workplace between employer and employee, or between members of management of the employer and their junior employees, but it also includes as between independent contractor and employee, for example, or I would imagine between two independent contractors as well, as between clients, as between consultants, as between the various persons that come into the workplace and the various persons that employees interact with outside of the workplace as well, which have some relevance. I think the other important thing to mention there, Anli, is that the Section 7 identifies other pieces of legislation that are applicable to the code, and PEPUDA is one of them, and obviously the Labour Relations Act. But what is specific in Section 7 is that it is not just the Employment Equity Act that the code seeks to sort of give a content to in the manner that it attempts to do, but it also seeks to give content to things like PEPUDA, and PEPUDA applies in relation to harassment, be it racial harassment between members of the public who do not necessarily have to be employees of a particular employer. But then because of the incorporation by reference of such legislation in the code, then employers will have an obligation to deal with such allegations, even if they arise outside of just a normal employer and employee, or employee versus employee, but will include even members of the public, etc., etc.
So the question has been asked whether or not the code protects and supports job seekers. The answer to that is yes, that applicants for employment are specifically included. I think the additional interesting question that was asked was about pronouns. Could an employee who chooses to not acknowledge another person's personal pronoun be liable for harassment? I think, correct me if I'm wrong, but I believe the code would extend to at least an inquiry into that.
I would think so, yes.
Then reporting requirements in terms of the Employment Equity Act, we still need some clarity onto how that will be handled. That's a very good question. I think, Bongani, just to finalize the question in relation to you about violence that has come up quite a few times in our discussion. We've spoken about gender-based violence. Initially, that was part of the, if I recall correctly, as part of the code's name, actually, the word violence was included. Do you have any insights as to why it was ultimately excluded when the code seems to be trying to tread into that territory in any event?
It was an interesting development when the final code came out, because the draft only was referred to as the draft code of good practice on the prevention and elimination of violence and harassment in the world of work. Now, I've already alluded to the fact that the code is a response to, or is guided by the ILO Convention 190, which, funny enough, is called the Elimination of Violence and Harassment in the World of Work. So I think there was a bit of, there's some copy and paste work there from the ILO Convention. But then it seems to me that good sense prevailed ultimately, because the definition of harassment in section 4.2 is cast so wide that actually violence is included in harassment. In other words, harassment includes violence. So then there was no need, I think, ultimately in the name of the code for there to be a distinction between, code of good practice on the elimination of violence and harassment, if harassment already equates to violence, amongst other things. So I think that's one of the main reasons that the definition of harassment includes violence. And of the specific instances or examples that we've made here, some of which include, violent behavior. Violent behavior is covered in the code as well quite extensively. It includes anything, that can harm the person physically, any use of physical force, power resulting or likely resulting in injury, death, physical or psychological harm to another person, which is strictly speaking violence. And we've seen a lot of violence during strikes in South Africa. There's an obligation for employers to actually eliminate or take measures to prevent that in terms of the code.
Thanks, Bongani. So, Imran, we know in terms of the Employment Equity Act, there's that principle of vicarious liability, and we know that the courts have been quite strict in their application, and that they'll hold an employer liable who doesn't do what they're required to do in terms of the Employment Equity Act. So all of that being said, where does that leave us, and what are employers now required to do in relation to implementation of policies? Do they have to train? What are the next steps, essentially? So,
morning, Anli, Bongani, Heda. I guess I've got the hot seat now. So it's a rather open-ended question in respect of where to from here for employers. But perhaps let's start at the very basic. So on the back of everything that Bongani and Heda have correctly said on the background to the code, the code starts out on the basis that harassment an employer is to adopt a zero tolerance policy to. That's the starting out point in the code of good practice. Which is an interesting starting out point, because many years ago, the Labour Appeal Court had taken the position in a SARS decision that even if an employer has a zero tolerance in relation to a particular form of misconduct, that zero tolerance is not a basis upon which an employer can effect a termination. So you remember the authorities in that regard. Now the code starts out on the basis of saying that an employer must have a zero tolerance approach to harassment. So that's where you begin. But the interesting bit in relation to the code is that notwithstanding the zero tolerance, it still allows for progressive discipline. So if there's a single form of harassment, well, that does not necessarily result in a dismissal. There's got to be a form of graduated progressive discipline. So even though it talks about zero tolerance, progressive discipline continues to apply. And in the more serious instances, obviously, dismissal would follow in appropriate circumstances. So Anli, I think that answers the first bit. The second bit is what is an employer meant to do after this? We know the code came into effect, I think it was the 18th of March, it's rather recent. What's important is that the code requires that an employer conduct a risk assessment. Now, we've all become quite familiar in this world post-COVID in respect of risk assessments. Now there's a risk assessment that's been required in relation to harassment in the workplace. So firstly, an employee is to conduct a risk assessment of harassment within its workplace. And I think it would be quite naive for any employer to assume that my workplace is sufficiently cordial that there's no harassment. Hera spoke about passive-aggressive harassment a little earlier. Bongani referred to violence as a form of harassment. So it exists all over the show. So to believe that it doesn't exist in any particular workplace, I think would be rose-colored glasses. So, and a risk assessment is the first place. Once that's been determined, the next issue, or the second point, is to put in place appropriate policies in order to deal with anti-harassment. Now, once that's done, thirdly is to create awareness in relation to harassment generally, what constitutes harassment. Hera and Bongani unpacked that quite well. There's different forms of harassment. Employees need to be informed about it. They need to be trained about it. There was an interesting question on the chat. Well, how do you deal with executive managers when it comes to harassment in training? Well, the code requires harassment training all the way through the organization. So at every level, there needs to be training. And the final point on that is the failure to deal with harassment complaints appropriately is going to expose an employer to vicarious liability ultimately. So if I can just finalize on this point, what's intriguing about the code is that this code hasn't been promulgated under the Labour Relations Act. It hasn't been promulgated upon in terms of the code under the Basic Conditions of Employment Act. It's being promulgated under the Employment Equity Act, and that's significant. And the reason for that is because harassment is now clearly defined as a form of unfair discrimination. So these forms of disputes were previously, there was lots of grey areas. So let's use bullying as an example. Bullying was a very nebulous concept. And I think we recall, I think it was a November-December session of 2020, maybe 2021, in the Center for Autism, I think it was, where Judge van Niekerk had found bullying was a basis for constructive dismissal in a review application in the Labour Court. But he came to that conclusion in the absence of an underpinning of what constitutes bullying in our law. Now, I say that because there was no concept of bullying prior to this. In South African law, there's been in Europe for a long time, but we haven't had it. Now, when an employee can show bullying and can prove it, that constitutes a claim under the Employment Equity Act. So it's quite significant from that perspective.
The code provides for certain procedures to be followed, and it refers to a formal, informal process, which what I've always found interesting is that it allows the complainant to a certain extent elect which process to follow. But just take us through that thinking. What if the complainant elects not to follow any process, or the complainant elects to follow a formal process where you may want to follow a different process? Where does that leave the employer, who's usually in charge of its own processes, to dictate how it's going to handle the complaint?
Well, it goes back to the initial point in respect of the harassment policy. So the harassment policy will now have an inbuilt process in relation to how to deal with harassment complaints. Effectively, let's call it grievances, because that's what they're ultimately going to end up being. So what the takeaway point is going to be is employers need to now refresh their grievance policies in order to make sure that the grievance policies effectively deal with harassment in the workplace and how it can properly be managed in the workplace. So harassment policies certainly need to be looked at. And then to get to the specifics of your question, Anli, the code, Hedda made the point a bit earlier, the processes in relation to sexual harassment, i.e. formal, informal processes, haven't changed. It remains in place. What the code has done is that it now provides that any form of harassment is to be dealt with either through a formal or an informal process, and that's important. Now, in an instance where an employee may elect not to utilize a formal process, because that becomes the election of the employee on a harassment claim, which is interesting because it kind of moves the prerogative, as you suggesting, from away from the employer, as it would be in relation to ordinary disciplinary matters, to the election of the employee, or what the code refers to as the victim, and more specifically as the complainant. So in other words, the complainant now has the election, as we've always known in relation to sexual harassment matters, formal or informal processes, where the complainant chooses not to use the formal process and wants to use an informal process. The code specifically says that the employer maintains the prerogative in particular circumstances to use a formal process. So if there are particular factors that come into play, in regard to the nature of the complaint, the seriousness of the complaint, the history of the perpetrator, the risk to the organization, then in that instance, even if the complainant does not want to use the formal process, then the code says the employer may do so without that election having been made by the employer.
So Sunay has raised an interesting question, and it seems to be a theme that's coming through in the questions generally. She asked if the perpetrator, and I'm going to direct this to Imran, if the perpetrator is an employee, you can investigate and take appropriate steps against the employee. But if the perpetrator is a client, how do you deal with this?
That's an interesting question. Interesting from this perspective is how does an employer now go off to conduct an investigation in relation to a third party? It does become difficult, but it depends who the third party is. If the third party is a contractor to the business, then there should be an obligation to raise the issue with the contractor. So the contractor's employer then is the obligation under the code, is the employer of the perpetrator to conduct the investigation. All of this becomes very important because of vicarious liability. And the code is very clear about it, and we've seen a significant development in our law over the last, I would say, 10 years, simply on sexual harassment in the workplace and claims against the employer on vicarious liability. Now, maybe it's got something to do with my age, and Bongani's many years younger than I am. I'm a little more cynical when it comes to what's going to happen with the code. I'm for the code. I think it's extremely progressive. I think we're certainly moving in the right direction. But because of my cynicism, Bongs, I think we're going to see a lot more of these claims. I think we're going to get very many claims coming through, some with merit and a fair bit of them without merit. The difficulty for employers is that every single one of these complaints of harassment absolutely need to be dealt with a fine comb, because that's what the code requires. Now, it goes, and Hedda made the point a bit earlier about investigations and how to conduct an investigation. The days are gone by in relation to running a grievance, excuse me, in the form of a tick box exercise. So an employee lodges a grievance and you simply go through the motions and get a grievance done. Because if there's a legitimate claim, to Bongani's point, and that gets to court, and it's proven that there's harassment, and it constitutes discrimination now under the Employment Equity Act. Under Section 60, the employer picks up liability for compensation, for damages, reputational risk, etc., etc. Now, the link to that, to the grievance, is that if the grievance was not properly dealt with, the person that's going to get hammered for that is going to be the employer. So back to the question, it's absolutely important that even in an instance with a third party, that where the complaint emanates, it's got to get back to the employer so that there's mitigation of risk for the, let's call it the primary employer as it were.
So Imran, where does that leave us? The question has been asked, is it advisable for employers to amend their current policies to be in line with the new code? I anticipate there's also possibly an obligation to educate and inform. What would you recommend employers do as a next step?
Well, I'd say as a next step, there's probably two things. Well, firstly is the risk assessment, right? So the risk assessment is important. What is the risk assessment in the particulars of a particular organization is really dependent from one organization to another. Historical information is going to be quite important. So if the workplace has been susceptible to particular forms of harassment, that needs to be identified. So if I can answer that question with reference to, I think Bongani had made reference to third parties on questions relating to harassment. So I'll give you an example. Take a cashier in a supermarket, right, that gets abused by a customer. Under the code, that constitutes harassment that employee may raise with the employer and has a claim against the employer, right? That's a cashier. Easy example. What about a call center agent? Right? And whilst the world has become more digital, and even call centers say to you, please don't call us, use our apps these days. But there's a person on the other side of the line, and I've been involved in too many of these matters to know that even call center agents get terribly abused by customers. That constitutes harassment under the code. So in that particular work environment, a risk assessment would have to look at all of those issues. Fast track, what do employers need to do? They certainly under the code are the code says should. It uses the word should have a harassment policy. Read the should as a subtle must. That's the takeaway point. That you must have a harassment policy going forward. Your sexual harassment policies need to be re-looked at. They don't significantly change under the code, but they need to be looked at as Hera correctly said, as part of a larger component of what constitutes harassment, because sexual harassment is one form of harassment going forward, and refreshing the policies and how to deal with it going forward.
There's a question from Ilse Nell. An employee who is being performance managed or disciplined about misconduct claims he or she is being victimized, bullied by the line manager. He or she now claims harassment. How do we deal with this? Heda, can you provide some insights into that?
Sure. So one would look at the history. Has that employee laid any complaints or grievances previously in relation to that line manager? And if they are, well, then the question is, how has the line manager, we need to first of all deal with the line manager and that conduct. And perhaps one then has to look at who is then going to perform that assessment going forward, because that obviously opens it up to sabotage and you potentially impacting my professional growth going forward.
Then Bongani, the question that I'd like to ask you is one that comes up regularly. And I think to go to Imran's point, it's one we're going to deal with, I believe, in the coming months and years following this code. And that is, what do we do with people who raises false claims in terms of these codes? So firstly, I understand from Imran that you have to investigate. You can't ignore. But now you've investigated and you found them to have been dishonest. Where does that leave you?
Firstly, Anli, I think the point that Imran makes is incapable of overstatement. As an employer, the obligation on you is to investigate any allegation being raised. You must investigate and satisfy yourself in light of the risk of the stick that lies in Section 60 through vicarious liability. Should later on it be found, let's say, by the court that somebody was indeed harassed under your watch as an employer, be it by a customer, a client, an independent contractor, or whoever else. So the most important thing is to investigate and satisfy yourself as the employer. If your investigation reveals that the allegations made by the person or the complaint is false, then it leaves the question of whether you have the appetite enough to pursue the person who makes the allegations disciplinarily. And most employers would have, enough cause to go after such a person disciplinarily. And as to the merits or demerits of that disciplinary action and where it lands up, whether it lands up in a slap on the wrist type warning or it lands up in a dismissal, I think would depend on the facts and circumstances of each particular case. But you cannot not investigate an allegation just because you have an inclination that or a feeling that it might be untrue. And once you have found that it is untrue, then it is open to you as an employer to deal with such a person who makes false accusations disciplinarily. I don't think much of that is changed by the court, but the emphasis is whatever allegation is raised, whatever issue or complaint about harassment is raised, your obligation, you're better served as an employer in investigating it and satisfying yourself.
I guess part of that inquiry would also be whether or not the complaint was made in good faith in the first instance. But that brings us also to the question, Imran, that's been raised, is what is the employer's obligation if the complaint is not reported by the victim, but somehow or anonymously comes to the attention of management, which we've experienced, I think, on a few occasions. In a conversation, someone just, by the way, makes a remark about harassment they've suffered, and you as the employer have now become aware of it. You can't look away, but what can you do if there's no formal complaint?
Yeah, only that's a difficult question. I mean, we've all faced it at some point in time where we confronted with a client situation of in those circumstances. It really depends. If the information appears credible, then I would say, and it's so dependent on the facts. If it appears credible, I've had an instance where an anonymous complaint was looked at. In fact, it was last year. A complaint of sexual harassment was raised anonymously. A full-on investigation was conducted. There were serious concerns of sexual harassment within the workplace. We got to the point that in the communication with the anonymous, let's call it whistleblower, who alleged that she was sexually harassed, not somebody else, and then started giving us bits of information in respect of other individuals, even though she was legally represented. When we suggested to her that we meet with her lawyers, she refused to do so. And so that's one extreme. But we were satisfied that, and there was no code obviously at that point in time, but we were satisfied that we'd done everything in order to properly investigate that, because we believe that, well, perhaps there was some credibility on the anonymous, let's call it tip-off. But there's been others where, like what Bongani says, you run a preliminary investigation and there isn't much. So it really depends on the facts. But the takeaway point, I guess, is what HR cannot do and what IR cannot do and what legal cannot do is when these complaints come to the attention of wherever the repository is to simply say, well, we're not dealing with this, because the claim and your liability down the line is real. There's serious risk associated with this.
Thank you, Imran, and thank you to the entire panel. I think just in concluding remarks, Imran, would you just take our guests through the e-learning product that we have on offer? And I'd like to take the opportunity to thank everyone. We've tried to address all of the questions as best as we could. We'll also be sharing a guideline. Please keep an eye out for our alerts and any further seminars that we may have on this topic. Imran, I'll hand over to you to close out for us.
Thanks, Annelie. So on the point of the e-learning tool, there's been a number of clients that have successfully rolled out the e-learning tool on sexual harassment. What we've got to be looking at going forward, and this is an important issue, is how does that tool get transformed in one way or another in order to deal with harassment generally, because it's been quite a successful tool. Successful in the sense that on one of the questions was, well, how do you get very busy people to deal with this? Well, you get people to use technology effectively to learn at their own time and with a proper record that people have been properly trained. Because without records, when you get to court without showing that you've done the training, becomes a problem for an employer. So it's important to have regard to that. And we'd be looking at either working up what we've currently got or putting something else in place in relation to other forms of harassment. So at least there's a starting out point in relation to going forward on rollout, training, evaluation, and to ensure not tick box compliance with the code, but substantive compliance going forward. So that's in the works, and anybody that would be interested in that must obviously speak to us, and let's see how we can get that actually rolled out going forward.
Thank you, everyone.
Thanks, Annie. Thanks, Bongani.
Thanks, Annalie. Thank you, Imran.
Thanks, Andy. Thanks, Imran. Thanks, Heads.
Thank you to all our guests for joining us. Bye.
Thanks. Bye-bye.
Thank you. Bye.